digital sphere, software has become an important part of contemporary inventions and creations. And it is, of course, also an extremely important part of intellectual property. In the one side in Slovenia and also in Europe. The software protection in the European Union, so that is in Europe, not considered fully arranged. And computer scientists face a number of challenges when it comes to exploiting intellectual property rights in software. The field therefore offers many opportunities for further work. And in our paper, which was presented at the 14th Technology Transfer Conference, we discuss software and focus mainly on the challenges computer scientists face in protecting and licensing software in the European innovation arena. The European Patent Convention stipulates that programs for computers are not regarded as inventions. European Patent Convention also excludes computer programs from patentability. There is also important to emphasize the distinction between software patents, which are excluded according to the distinction between software patents, which are excluded according to the aforementioned article of this convention, and computer implemented inventions, which are accepted by European Patent Office. So yeah, in the following, software that does not demonstrate a technical contribution can only be protected by copyright, which does not protect ideas. And yeah, although the European Patent Convention excludes computer programs from patentability to the extent that the patent application relates to a computer program as such, this is also interpreted to mean that any invention that makes a non-obvious technical contribution or solves a technical problem in a non-obvious way is patentable. Even if the technical problem can be solved by running a computer problem. Yeah, software theory and practice. Today, the three largest patent offices in the world, so in the European Union, United States, and in the Japan, allow patenting of certain software, although there are differences in the criteria they use when accepting applications. In the USA, for the example, all new and non-obvious software that produced a useful material and tangible result is eligible for patent protection, whereas in Europe, the technical contribution of the invention must be defined as described, so also applies to Slovenia. And of course, these discussions led to the widely accepted principle that computer programs should be protected by copyright, while apparatus using software or software-related inventions should be protected by the patent. Yeah, licensing plays an essential role in creating value through management of intellectual property associated with software development. And also business models are formalized in a contract, usually in the form of licensing agreements, which impose specific rules of use on third parties who intend to exploit the software. In this picture, so figure shows some typical software licensing models. We can see free and open source software rights include use, inspection, and modification and distribution of modified and unmodified copies. They typically allow it to be used for any purpose without restriction. And when the code is reviewed and modified, it requires that the modified code is made available again under the same conditions. The rights also allow distributing modified and unmodified copies of the software. And when free and open source software is modified, derivative works are created. And when various components of the software are assembled, composite parts of the underlying components are created. In this topic, we consider the following types of such licenses. Firstly, academic licenses are extremely open. Permissive licenses which allow licenses to perform, modify, and distribute derivative works without restrictions. Although licenses for derivative works may lead to new licensing terms, including proprietary ones. For the example, such licenses are generally accepted in academia arena. Secondly, contextual licenses allow licensees to use, modify, and distribute derivative works, provided that the derivative or composite works are distributed under the same license. Specific form of such license is called a copyleft license, which is the practice of granting the right to freely distribute and modify intellectual property with the requirement to preserve the same rights in derivative works created from the property. And thirdly, reciprocal licenses are very complex as licenses of major works using an unmodified version of the original component under a contextual license are not limited by the original license, and derivative product containing a modified component must be released under the same license. Many different types of contractual relationships or contractual sets of rules can be derived from proprietary licenses, and all of which typically require a financial contribution from end user. Exceptions in this place are freeware, where the software is available free and free of charge, but any modification of the code is prohibited. And secondly, shareware, where the user is free to use the software for a limited period of time or with limited functionality, but in order to gain access to the full unrestricted version, an additional license must be obtained. Something about software and exploitation of intellectual property rights, so management of IPR for software. In this place, two basic issues should be addressed in the assessment and planning process. So first question is, why was the software created? And the second question is, how was the software developed? Yeah, however, if the software is protected exclusively by copyright, it is possible to easily circumvent all prior rights as long as we have access to the source code. So the same idea can simply be implemented in another source code. Conclusion and steps for our further work. Of course, the situation of software in the European innovation arena can still be considered as neither resolved nor uncertain in legal terms, thus raising a number of open questions and opportunities for our further work. So TTOs, propose that regular reflection among computer scientists within public research organizations is facilitated on a new marketable software code. That verification is introduced to any technical contribution, and that innovation based on software code is registered accordingly. Of course, TTOs plays a key role in this respect, and yeah, as their specific expertise contributes to the proper assessment and registration of service inventions, as well as to the wider popularization of software commercializations. Yeah, there's also important protected and registered in this way. And in the end, at the same time, the proposed methods allows computer scientists working in the field of software code, so development, to be rewarded for their work. Thank you for your attention. And now we will available with Robert for your questions.
Thank you very much for the presentation. Does anybody from the public have any questions for Urška and Robert?
Sorry, can you hear me?
Yes.
Okay, hi, I'm Albert from Semmelweis University in Budapest. So my question is that we work with medical softwares, and a lot of it is basically AI, right? Artificial intelligence. So you used the terminology as programs or softwares, but when we discuss AI, which is really like a big piece, and everybody's thinking how to protect our AI, how would you consider that from the perspective of what you have just described?
Urška, if I can answer this. I mean, thank you for the question. AI is really relevant in this last couple of years, also in the EPO. But AI is considered as a computer software. So we don't have a distinction between AI and other computer software. Basically, it is a computer software. The issues in AI are a little bit even further challenges. For example, now, as you might heard, this year was first in South Africa. There was one computer software, AI software, which developed, which was basically contributing to a patent, to an invention, which was receiving a granted patent in South Africa. This was first time in history. So there are a lot of issues with regard to the inventions which are created with the help of AI. So who is the author, basically? And of course, the rules for authorship are not allowing to be the computer software to be author of the invention. So yes, indeed, AI is a challenge, but to directly answer to your question, we don't distinguish with other types of software. Basically, it is a software. So we need to see the technical effect of the software. So it must be it must be in connection with some specific device, actuator, something that does something technically, not just showing the information on the screen, for example. I hope I answered briefly. Thanks.
Thank you. Does anybody else have a question? If not, maybe I'll try. I'll be the one who will put a question. Do you think that, again, as from the previous presentation that we had, yeah, in the sense that the idea of actually that once with the development or becoming more digital with the development of different types of softwares and becoming more and more dependent on computers, yeah, let's say like that. Do you think that in general the IP protection topic or the as intellectual property protection, yeah, did it change in the sense that it became more, or did it become more complicated, the aspect of IP protection? Yeah, or and probably a sub question whether this the IP protection in the case of softwares, yeah, would actually see some developments and become a little bit of a burden for us, let's say like that.
My personal opinion, I wouldn't say it's more complicated, but there are definitely challenges, as we said, with new technologies, which are side effects of the software development, for example, artificial intelligence. So it's not, I wouldn't say it's more complicated. The IP protection in terms of invention protection, patent protection is traditionally thing, and it's always evolving. As you know, the classification codes, specific classes in patent protection are constantly developing. Some classes are going out and some new are being developed. So this is, as technology evolves, also new fields are being protected. So I wouldn't say it's more complicated, but it definitely adds challenges also in the copyright protection, because it's not the same as if you protect some text which you write in the article, but it's basically your idea, your technical idea is being transferred into technical software programs. So that's the challenge which we have all with us. Yeah.
Okay. Thank you. Maybe from the public, did any questions arrive until now?
Yeah, I have a question. Let me, because I think it's a big problem with software patenting. Let me know if I understand right. So if you have artificial intelligence recognizing a face and opening a door, this can be a patent.
In principle, yes. If you have some, but let's say computer program, not artificial intelligence, because it's not directly related to artificial intelligence. But let's say computer software is identifying a person. So there is a mechanism in a software which sends information to actuator, and the actuator is opening the door. That's basically what you described right now.
Yes, yes,
so
yes.
Such invention might be protected if it is new.
Well, it's not new, but I was just asking because I was trying to assess the level of complexity, because what I just say is very simple, actually.
Yeah.
It's not a complex problem.
Yes, if under condition that this is new, inventive step, and it's technically feasible, it can be protected. Such a device. So if you are saying as an algorithm, some process which is then acting to the actuator which is opening doors. So this device, so this device can be protected, but again, if it's new.
No, it's not new, but I was just
new, but as a principle, we can say yes.
Yes, and just to give you another example, so the same software, which is recognizing faces, is scanning billions of photos in order to recognize a criminal and identifying the criminal, but without catching it, because it's just saying, okay, this guy is the criminal, is sitting at that address and so on, without physically catching, because you don't have a device which will go and catch the criminal. This is valueless, so to say, so it's not an invention.
Yes, so what is the question?
So this cannot be patented as an invention.
Just as a provider of, if software is just providing information about identification of persons, I would say no.
Okay, thank you.
Yeah.
Okay.
Sorry, just a clarification, because I think it's an interesting question. So if there is like 200 softwares that can recognize faces and open a door, how, if I'm the number 201st who comes up with a new software, which is also, you know, recognizes faces and open doors, how would I prove that my one is something new? It is based on new codes, so I deserve protection, right? So I need my own protection for this software.
So the question is how would you check if your invention is new? This is basically a question.
Well, yes, or how those who grant the protection for my software would know that my one is genuinely new, and or I'm just copying something.
I have only 2 minutes. I apologize because I have a next meeting, but I will be very quick. So basically, first of, if you're an inventor, you need to know what is the core of your invention. So you need to check all the databases across the world, all articles, whatever is available publicly. If you get any solution, if you find any solution which is similar to yours, this is very, very broad. So if you found anything what is similar to your solution, then you might consider that your invention is not new. But in order to get protection, when you file a patent, there are patent offices, which are, some patent offices are having, I have some telephone calls, are having search, patent search, and if they find specific people which are skilled in the state of the art, they are searching the patent databases. If they find something which is not considered, which is considering patented or put into practice or into public before you file the patent application, then you don't have novelty. This is very, very quick, but now I need to go to another meeting. Sorry.
Okay. Thank you very much.
Thank you. Thank you.
Thank you very much. And good luck with the following meeting. So maybe just if anybody has a very short question for Urška, because Urška, as I understood, is also involved in other activities, is having another meeting. So just feel free to pose the question. Okay. Okay, then Urška, thank you again for the interesting and nice presentation. And now